Okay, hi everyone.
Hey, good evening.
Thank you all for coming out. My name is Casey Burke. I am the executive director of a nonprofit legal service organization called Climb. We do education on business law matters around the community, and we also can represent small businesses who otherwise would not have the ability to afford an attorney. And I'll tell you about that process and eligibility at the end and the kind of work that we do. But before I get to that, I want to introduce my colleagues, Andrew and Sean. They are both business attorneys. They both assist with setting businesses up and then assisting businesses throughout the life stage of the business. Andrew is with Practice, and Sean is with Sean Garrett Law Firm, PLLC. Garrett Law, yes. And so because we're lawyers, we always like to talk about this important little provision down here, which states that this is not legal advice. We are lawyers, but we are not currently your lawyers, and this does not form an attorney-client relationship. However, that being said, as we talk, if you have questions, keep it interactive. Feel free to raise your hand. The Mecklenburg County Bar Association is partnering with this, and they are recording it. So if you have anything that's really confidential to your business that you don't want public, don't raise your hand during that portion. You can come up and talk to us about that later. But without further ado, Andrew and Sean.
Perfect.
Yeah, thank you, everybody.
Just a housekeeping measure. Shelby, the lights turn off on this. Is that correct?
Yeah,
It's still going? Okay, just want to make sure. Sorry. Well, just brief introduction. My name's Sean Garrett, as Casey said. And what's unique about my practice is I'm very much like you guys. I'm a small business owner. Started my business 5 years ago with the intent of helping small businesses get off the ground and form their practices all through the different growth stages of business. Now, Andrew and I are going to talk quite a bit about business law and the intricacies of what to look out for as you proceed with starting your business and growing it from there. One of the things I like to start with is stating that hiring an attorney is cheaper in the long run than the difficulties that can ensue if you don't. And so if you have any questions, feel free to ask them as we speak. Andrew and I, we like being interrupted. We don't get in the courtroom, and so if you want
Used to
interrupt
get in
us,
the courtroom. I was interrupted quite a bit.
yeah. So feel free to ask questions, okay?
Yeah. There's more from the judges.
For sure.
Yeah, good evening, everybody. I'm Andrew Vining. I'm also a corporate attorney with the law firm of Practice LLP. Like Sean, we have a similar business model in how we run things. I look at my own practice as my own small business, and look to help people from startup to exit. My practice is a general corporate practice, so as I've said, from startup to exit, pretty much everything in between. I also do commercial leasing and some, I guess, loan document review and let's just say a loan practice, if you will. And I'm really happy to be here. And I echo Sean's sentiments in that if you have questions, please do not be bashful. We are here to answer and help. And without further ado, I'll go ahead and start if you don't mind.
Yeah.
All right. So, as Sean said from the get-go, consulting with an attorney is the most efficient way to get a business off the ground. There's obviously, LegalZoom, do-it-yourself out there, but it can be complex. There are tax implications. There's a lot of moving parts when it comes to starting a business. So the first item on the agenda is going to be selecting the right entity for your business, and we'll get into that a little bit more. And then you've got business licensing, permits, and regulatory compliance. Not applicable to all businesses, but businesses in the healthcare space, real estate businesses, that's probably going to be more applicable to you. Then you have written agreements among partners and founders. We'll get into that in a little bit. One of the central ideas behind setting up a business is to limit your personal liability and exposure. And we will explain how the various business entities can help you do that or not help you do that. And then funding your business. How do you fund your business? Do you fund your business through loans, also known as debt, Or do you fund your business by bringing in partners or outside investors, which we would consider equity, or even employees, giving equity to employees, and then acquiring a brick and mortar space? What do you have to do that? I mean, do you have leases? Are you looking to purchase? A lot goes into it. Employment classification is something we're going to briefly touch on. We may briefly touch on if we have time. That can get very intricate, so you want to make sure that you potentially consult an employment attorney on that. And then growth and exit strategies. We're going, as companies scale, I guess you can say, encounter different challenges. And if we have time, we'll briefly discuss those. And when your company gets big enough, or it's where you want it, and you look to exit, there's certain things that you should be looking out for as well.
Perfect. So when we talk about choosing an entity, one of the things that I like walking through with clients is we can advise. We can advise you what the law states, what the state says, what the IRS says from that standpoint. But one of the things that you have to think about as you start your business is risk tolerance. And a lot of times that's intangible. That's not something that you've ever really thought about before. If you're working for a company, they will tell you what their procedures are, and they'll tell you this is our risk tolerance and this is what we're willing to allow. And so when I start describing some of these entities, similar to a sole proprietorship, some clients will ask, well, is a sole proprietorship right for me, or is an LLC right for me? And I know these are all high-level concepts now, but a lot of that is determined by me or your attorney explaining what those different entities do and how they operate, how much they cost, and what benefits, pros and cons they offer, and then you making the decision as the business owner. So some of the entities, that's not on the screen, I'm probably getting ahead of myself, but when we're choosing an entity, some of the considerations are the complexity of your business, how complex you want to establish your entity to be, liabilities, what potential liabilities you could be exposed to in your business. If you are crocheting socks, there's probably a lot less liability than if you are building sheds. And so a lot of that really is that risk tolerance that we're talking about. If you are selling socks on Etsy, it's probably a much lower risk than if you were building sheds in people's backyards. So maybe we'll lean towards a sole proprietorship, which doesn't offer liability protection, versus an LLC, which would offer that liability protection, which we'll get into more. Taxes, we all love them, right? Uncle Sam. So taxes are also extremely important, and different entities are taxed differently. We're going to talk high level about tax classifications. I'm going to give you a little bit of a cheat sheet when you're talking to people and they reference the term S Corp. We'll get into that in a little bit, but you'll realize that that's actually a tax classification. It's not an entity that gets filed. And then you'll also hear from us discussing that C corporations, which we'll get into in a bit, are taxed at a much higher rate, or even double taxed in comparison to some other entities. So those are three of the four considerations: the complexity of your business and how complex your business requires your entity to be; liability, whether you need liability protection and what that liability protection looks like; taxes, whether your entity would benefit from double taxation of a C Corp or pass-through taxation of an S Corp or an LLC; and then the last piece is equity. And the equity is extremely important because, and I don't want to go too deep into this yet, but when it comes to starting your business and growing it, funding is extremely important. And you can get funds from many different places. You can either be born wealthy and have funds given to you. You can have funds come to you from a W-2 employer that you've saved. You can have investors come in, and then they potentially may want to have a different level of equity than you. Or you can get debt, and you can go to a bank, and they can issue you funds that way as well. If you are getting funds from an investor, that's where the equity piece comes in. a lot of times, and we'll talk about this a little bit more in depth later, a lot of times an investor is going to say, you've got the idea, but I'm putting money into this entity, and therefore I want certain rights and provisions that protect me versus you. I don't want to put this money in and you go buy a nice car. I would like to have a say in that. So those are some of the considerations when we're setting up businesses that we talk through. And one of the last things I'll touch on before we go to the next slide is there's no universally best, correct, right entity. This is a living, breathing baby, your entity, your business. And so we need to discuss what that entity looks like and what the necessary structure is for it, depending on how you're planning on operating it.
Very well said. And to, I guess, piggyback off of that a little bit, what you start out with may not be what you end with. As Sean eloquently said, it's basically your baby, and your baby grows and evolves just like a little human being does. So, there's a way that you can move from one structure to the other structure as your company grows, and it's important to remember that whenever you're first starting out. But going to the slide before I went on my tangent, I will start out with, we're going to start with sole proprietorship. So this is known as the default, default entity. So this is where you don't file anything with the Secretary of State. There's no incorporation costs. There's no ongoing costs that come with an LLC or a C corp. It is literally you. And so when it comes to taxes, you report your income and expenses on your personal tax return, and you don't need what's called an EIN, which is also known as an employer identification number. You and the business are one in each other. What are the cons for this? Well, number one is that there is no liability protection. So if you get sued, it is all you. All your assets, everything is on the line, depending on what's going on. And that is a huge risk depending on how much assets you have and the level of potential liability at stake. Number two is that it's difficult to grow. Investors want to see governance. They want to see an entity that has that's operated by something that gives them potential rights, gives you potential rights as to how the company operates. And we'll get into those documents a little bit more later. But that's when if you think about a sole proprietorship as me, myself, and I, it's difficult for somebody to come in and say, well, I'm going to take a piece of that. And then lastly is that you can't take advantage of small business loans. Again, it is you and yourself that is the business. So there's no entity for the lender to lend money to. So you would take out a personal loan, which could be a hard loan, which means that they'll take collateral, or it could be a soft loan where they take no collateral, but it goes on your credit, and it is your loan. It is not your business's loan. So that's a sole proprietorship. As I said, it's the default entity where people start a business if they haven't formed anything. And I think we can move to the next slide.
Perfect. Thanks so much, Andrew. Talking about, we're still on sole props. Okay. Small scale. Do you think we still need to go through sole props?
I can do it if you'd like.
Yeah, if you want
yeah,
to finish out
I can continue.
That's fine.
So when is the sole proprietorship potentially the right choice for you? Well, as Sean said, it's not a one-size-fits-all. So if you're looking to do small-scale and solo operations, this may be a right fit for you. So you're thinking, Sean gave the example of socks on Etsy. That's probably a really good example where you're going to have pretty low exposure on what you're creating. But you see it with consultants, freelancers, where you don't need. You don't have this concept that's going to require even a minor infusion of cash. it may be a side hustle, or it may be something small that you start out with. Risk tolerance. So you're looking at a low risk business. You're looking at a business that produces something that is not going to create potential harm, potential liability to customers. I guess customers can get allergic reaction from socks, but good luck finding an attorney to take a case on that, unless it's really, really bad. So that's a good example of really a low risk business. And then, what are your long-term goals? Are your long-term goals to scale up to where you build this company, you build this baby, and the baby continues to grow and becomes a toddler, becomes a teenager, and then the baby gets to adulthood, and you're like, okay, well, I'm ready to exit. I've done all I can, and I'm ready to turn my business over to somebody else? Or are you looking to do something, again, similar to a side hustle, where it's just going to be you? You're not focused on leaving it to anybody else or anything else. And if that's the case, then sole proprietorship may be you in that instance. And as the slide says on the bottom, and as I think the major refrain has been so far, you can always change your mind. This is not a static. It's not a static structure. You can always form an LLC, form a C corp, and it would be a little bit more complicated depending on what assets you have into your business, but you can put that as a infusion of capital into your business, and Sean will probably go over that a little bit more. But you can make the next step to an LLC or a C corp as you grow.
Perfect. Thanks so much, Andrew. One item that I want to talk about regarding liability before we get into LLCs is that I talk to clients often who try to discuss with me and themselves their risk tolerance and liability. So liability is the exposure that you have to the outside world for the actions that you take, whether or not someone can sue you. I like to say anyone can sue anyone for anything at any time, but the likelihood that they will actually recover. And one conversation that clients often bring up to me is, well, Sean, I have nothing. And I don't like that argument on their behalf, because you may not have nothing now, but if you want to continue to have nothing ever in the future, then that's a great way to continue thinking about it. So I would say whether or not you have something now or you have assets now, you still want to protect yourself from future liability. So.
Absolutely. And you have to think I'm sorry for interrupting. When you think about this, again, it's not static. You have to think about it as potential growth and what this may mean for you down the road. And I think what Sean said is fantastic, in that, just because you feel like you have no assets now does not mean that you're not going to have assets down the road. And even if you think you have no assets now, you may have more than you think. So it's I used to do some creditors work, and you'd be surprised what people can find. So it's definitely be careful.
Yeah. I'm going to talk about LLCs, but before I do that, I want to rip off the Band-Aid, and I want to tell you the 3 entities that we're going to be discussing tonight. So when you're taking notes, you can write notes under each one. It's funny, I've got a lot of sayings. Ripping off the Band-Aid's one of them. My paralegals write them down on a board, and they quote them back to me. But the 3 that we're going to be discussing are sole proprietorships, LLCs, and then C corporations. So those are the 3 umbrella entities that we're really going to be discussing. So now we're going to move from the first to the second, LLCs. LLCs, as we've discussed tonight, is the first entity where you've got that limited liability protection. LLC stands for Limited Liability Company. So it's the first entity that we've discussed that gives you that liability protection. What does that mean? If someone wanted to sue you, if they want to sue your business for something that you've done while operating under the entity, which is extremely important, we'll get to in a second, they would name the business. Now, if the business was operating properly with limited liability protection, then they would not be able to access your personal assets. So let's say you have a home in the state of North Carolina and it's in your personal name. If they were to sue the LLC and the home was not in the name of the LLC, that should be a separate asset. Now, being a lawyer and me using terms such as should and possibly, we can't give guarantees, but what's going to determine whether they're successful or not is called piercing the corporate veil. Now, the corporate veil is this imaginary veil, thin curtain, we can call it, between your business assets and your personal assets. If a lawsuit occurs, a very clever attorney is likely going to try to pierce that veil to get at your assets. Especially being a small business, they're going to want to say, we want something that can pay whatever judgment we decide to obtain in the future, or we're able to obtain in the future. The way you keep that veil intact is by having a separate bank account, having separate credit cards for your business. I'm not a big credit card fan, but I do recommend them in the business sense because it's easy to pull out a company credit card and say, I'm going to put funds on here rather than your personal credit card. As soon as you decide to swipe your personal debit card or credit card and you say, oh, I'll just do it this one time becomes 100 times, and then your bookkeeper, CPA, accountant doesn't know which is which, and then especially with the limited liability company where they're filing taxes on your own tax return for the business, it's commingled, therefore that corporate veil is likely going to be pierced. So, how is an LLC formed? It's formed by filing articles of organization with the North Carolina Secretary of State, or depending on which state you're in. If you're in South Carolina Secretary of State. And once the articles of organization are filed, you'll get stamped copies back from the Secretary of State, and they'll say, congratulations, the name that you have selected is filed, and you're good to operate. What goes on the articles of organization? The articles of organization include the name of the business. It includes the registered agent name. The registered agent is very important. Simply, all that person does is they're able to receive mail or lawsuits or notices on behalf of the entity in that state. So most states require that you have a registered agent in that state. North Carolina certainly does, meaning that you need to have a physical address in that state. You cannot file articles of organization with a P.O. box. So that's something very important to keep in mind. Other items that go on there, you're going to need an organizer. It could be yourself, it could be an attorney, but it's just someone who signs the bottom of the articles of organization. Generally speaking, you don't need the names of the members or the owners, which I'll get into in a second. You don't need the names of the owners of the entity on the articles of organization. But when you go to file your annual report, which I'll get into in a second, you will have to list those. An LLC has two different types of individuals that are involved in the LLC. The first is going to be the members. The second is going to be the managers. Members and managers a lot of times are the same. They don't always have to be. The members have forward-looking authority in the entity. Whether we're going to hire an employee over $50,000, whether we're going to sign a new lease, whether we're going to take on debt, all of that's governed by the membership. Managers, they have more day-to-day authority, whether we're going to approve a work order, whether we're going to give someone a day off. That's more management authority. You don't necessarily have to have the same person that's a member as a manager, but a lot of times they are. So make sure I stay on track here. Flexible taxation. So there are a handful of things I'd like you to take away tonight, and most importantly is this piece here. When it comes to an LLC, you're going to hear the term S Corp, and it gets very, very confusing, but we're going to cut through all of the noise and just advise that an S Corp, it is a tax designation. An S Corp can be, and I don't want to confuse you guys, so I'm very hesitant to say this, but an S Corp can be an LLC. It can also be a C Corporation. The only entity that's advised that you are an S Corp, if you are an S Corp, is the IRS. The Secretary of State doesn't necessarily care. The Department of Revenue locally probably doesn't care. I don't know. I got to think through that one. But an S Corp really just tells the IRS you're going to be taxed as an S Corp. And what does that do? It says that it decreases the amount of taxes that you pay, whether you're a C Corp or an LLC. So if you're an LLC, you are going to be taxed as a self-employment tax. There's a self-employment tax that gets imposed on an S corp, and on an LLC. If you are an S corp, that self-employment tax goes away. The caveat to an S corp, because you're probably thinking, why doesn't everyone just elect to be an S corp? As an S corp, you have to pay yourself a reasonable salary. The reasonable salary, what does that mean? I don't know. Neither does the IRS. But the reasonable salary, it really is dependent on your industry. It's also dependent on how much you've made. So if you are an S corp and you are bringing in, let's just say $100,000 a year, and you pay yourself $5,000, you tell the IRS, hey, I only made $5,000 this year, and I'm an S corp. They're probably going to look at that if you're audited and say, that doesn't make sense. We're going to abolish or terminate your S corp status, and you do not want that to happen. Once your S corp status is lost, you cannot get it back with that entity. It's an uphill battle. Maybe you can get it back, but it's going to be expensive. So you really don't want to do that. If you are an S corp and you have multiple members, you do have to pay those members, the multiple members, a reasonable salary. So something to keep in mind. I tell my clients, we don't want to elect to be an S corp right off the bat unless we're anticipating that we're going to be able to pay you yourselves as owners a reasonable salary, because we don't want to lose it. And so that's just something to keep in mind.
If I may jump in real quick, so with the IRS, you're not only concerned about losing the S corp status, they'll also tax you on the whole thing. So, and they're going to include penalties and interest. So it's something that you really don't want to deal with when it comes to the IRS, and they are very notorious and ruthless, if I may add, about seeking those penalties and interest. Yes, please.
Of course.
So just thinking as a sole proprietor, where all of what I'm making right now goes to pay my bills, whether it was a business expense or not. If I wanted to go to an LLC, and I am paying myself pretty much 90%, if it's not a business expense, I'm paying myself with the remainder. Does that qualify and be a good candidate for an S corp?
So you cannot tax a sole proprietorship as an S corp.
Right, but if I were to switch from a sole proprietor
To an LLC.
to an LLC, I get the protection that might be needed. And then that's where it gets tricky. It's like,
A lot of what
it's just me and I don't have employees yet,
a lot of the reason why companies choose the S corp status is to lower self-employment taxes. So if logically thinking, if you're paying if everything is going to you or company expenses, then I can't make that call either way, but it may not make sense. For instance, let's just say, you're hanging out you're an attorney, and I can say from experience, okay, you're hanging out you have your own practice, and you think you know a reasonable salary. IRS may decide, okay, well that's not a reasonable salary, but you think you know what a reasonable salary is, and it's not going to be everything you're bringing in, then it's probably that would probably make a little bit more sense. But again, that's something that I would recommend talking to a tax advisor and getting that straightened out.
Another consideration, I want to touch on this real quick and then we'll come over to this question, is how much the tax return costs for an S corp. Because generally speaking, you're going to find that accountants are going to charge you around $2,000 to $2,500. That's most of what I've seen for an S corp tax return. Most of the accountants that I talk to and that are on calls with me and my clients, they will do the math to determine how much the client paid last year, how much it's going to cost them if they were an S corp, and sometimes that doesn't make sense. And they'll say, you're going to pay maybe $100 more in taxes. Does the time you're going to spend preparing for an S corp tax return and the amount that you're going to spend, does that make sense yet? The answer may be no, but Andrew's absolutely correct. Talking to a tax professional is key.
I do want to be clear that you can potentially you can revoke yourself. You can revoke your S corp status by writing to the IRS and revoking it. but you still are taxed as an S corp for that year.
For that year.
So it's not set in stone for the rest of your business's life, but it is, you are stuck with it, for lack of a better term, for a year.
I think we have do you have one more?
I was processing, sorry, I do think.
You're
there was
good.
another question. I was
Please.
thinking too,
Yes, sir.
I was just asking, so like if you're running an LLC out of your like garage or something, and then you get sued, is that going to be is your garage going to be online or your house?
It all depends on what, there's a lot of stuff that goes into that, to be honest with you, in terms of commingling assets. Because, if it could potentially be, but again, if you own the house individually, you have a separate bank account, you have, you observe the corporate formalities, it's going to be a little bit more difficult for them to touch it if it's not in the name of the LLC. But again, there's as Sean will tell you, there is no black or white answer to that question, because it depends on number one, what a judge thinks, and if it goes to trial, what a judge would consider, and once you put it in front of a judge, it's all bets are off, for lack of a better term. Yes, ma'am.
So you mentioned for the North Carolina, to file the articles of incorporation, you need a physical location in North Carolina?
Or a registered agent.
Registered agent
okay.
location.
Yeah,
Yeah.
because I was like, I don't have a separate office, and I wouldn't want my home address to just be like floating around out there. So if you're in that situation,
They have companies that can handle that. If you Google registered agent companies North Carolina, there'll probably be 10 of them.
Yeah.
And they can handle the registered agent service, obviously for a fee. But again, as Sean said, they're receiving your company's mail, and they're receiving summons and lawsuits. So it's really more of a formality over anything else, but it's a necessary formality that North Carolina and pretty much every state, if not every state, requires.
and does Climb or someone else have like recommendations for like ones that aren't rip-offs or something? For example?
I'd recommend if you have a lawyer or if you know of lawyers, a lot of lawyers will act as registered agents as well. So I like lawyers better than the corporate giants, because sometimes they may or may not get you your mail. I have had a lawsuit served on a client, and they went to the FedEx location where the registered agent was receiving their mail, handed it to the FedEx employee, and then the FedEx employee was like, I don't know what this is, so then they threw it to the side. And that counted as service in a lawsuit. And my
Right.
client actually had a judgment entered against them, and they had never known about it. So what's nice about, so what's nice about lawyers is if a lawyer receives a piece of mail, there's going to be some responsibility there. If a law firm received a summons for you and we didn't let you know about it, or they didn't let you know about it, there's significant liabilities there. If
But in that
a corporation
case, you
did.
would have to be like paying to have a lawyer.
No, I'll just be transparent because we offer this service. But it's $150 a year for our registered agent services. That's not a pitch at all. But I'm just saying that's what we offer.
Okay.
And so, and that includes the annual report filing service. It doesn't include the fee for the annual report. But it's not like we have ongoing representations for some clients that we are registered agents for. So.
Yes, sir.
Could you use a post office box versus you have to use a physical?
Yeah, you have to have a physical address.
Okay.
But the caveat that I wanted to point out when it came to using a registered agent to hide your personal address, so the first year you can do that. That's perfectly fine. You can file the articles of organization, use a registered agent, not list the members. That's perfectly fine. The second year, the Secretary of State is going to demand to know who the members are, and then you have to list an address. So I would recommend in that case you could use a P.O. box for your personal address. But if year 2 comes and you don't have that address, then they're still going to get your your personal address.
But you can use a PO box for a year too, just not.
For your personal address, but not the registered agent address. It gets
Registered agent
confusing.
always has
Okay,
to be
yeah, this is
physical
very
address.
It gets confusing.
Yeah.
Let's keep it simple. So the registered agent, when you look at the LLC on the Secretary of State website, you're going to see three main groups. The name of the LLC, the year it was organized, all the information about the LLC. Under that, they're going to see the registered agent name, and they're going to say, how can I serve this person? That'll be the registered agent with their address. It may be you if you live in North Carolina. It may be your address. It may be your registered agent. It just depends on who you decide to have as your registered agent. Under that, it's going to have the names of the members and potentially the managers. That is where, even if your registered agent is an entity or it's someone that is an attorney, it's not you, it's not your personal address, in that box down at the bottom, that's where the Secretary of State is going to say, we need to know who the owners are. They may list your personal address if that's what you give them.
Or your PO box.
Or your PO box, yes.
Right.
Yes. Question right here.
Yeah, it was back to, so we're trying to figure out, do we do LLC, S corp, or like I did a big AI deep dive and was like, you could be okay because you've got a great umbrella policy. And so we're kind of like, do we talk to an attorney or a tax advisor? And when do you need both? And at what point do you know who to talk to? Because we get confused, like, oh, you do the same things, but you don't do the same things.
There is significant overlap. If
Yeah.
it's liabilities, I would talk to an attorney. If your main concern is taxes, I would talk to a CPA. I would really think about what the concern that's keeping you up at night. If it's talking taxes, the better answer is talk to both, if I'm being completely honest.
Right.
If you find someone that offers a free consultation, you'll get all the information you need, most likely from that consultation.
On your website, do you guys recommend any particular CPAs in town?
I know a few. We can talk afterwards.
Yeah, I can't endorse them publicly, but we know some CPAs.
Perfect.
Did you have a follow-up? I think you were.
Oh, I think I answered it in my own mind and to the others, actually. And it really was about, all right, so it really should be weighing the value of liability protection to the cost of additional taxes.
On the legal
That's
side.
where it comes down to. What's that?
So on the legal side, you're looking at yes, you are looking at the liability aspect. I don't give tax advice. I'm not a CPA, so if you're concerned about how much taxes you're paying, as Sean just said, I would talk to a CPA.
So, and I think it just comes down to, all right, what does if I need the liability protection, that is more important to me, I will pay the additional taxes to file the higher cost of the tax return. You know what I mean? It's like, I'll pay more to get that liability protection with an LLC versus a sole proprietor. Because I don't want to lose my house if something goes wrong.
So I'm going to back up because I may have confused
Okay.
that conversation. I do not believe a tax return is going to be more expensive with an LLC
Okay.
by itself. I'm not a CPA,
Okay.
but I don't believe it's going to be more expensive. It's going to be more expensive if you file as an S corp.
As an
Right.
S corp.
Because you have to file a separate return for your S corp.
Got it.
Mhm.
Okay,
So-
so it's the S corp,
Yeah.
it's more, it's not just the LLC itself.
Correct.
The LLC gets filed on your same tax.
Correct.
Personal tax.
Pass-through
return.
taxation.
That's
Pass-through,
completely
yeah.
separate.
It will be the same tax return that you're currently filing.
But the finances, no commingling, I guess.
What I would say is, at the end of the year, and this is all tax advice, which we
I'm
get into.
sorry.
But no,
It
it's all,
does cross the line,
it's
right?
fine. We dance around it. But if you're bringing in enough revenue, you're likely going to have QuickBooks that will be provided to your accountant, and there'll be a P&L, and they'll say, okay, this is the profits, these are the losses, and they'll understand how to report that on your tax return.
Okay.
Right.
That's probably the easiest way of putting that. So,
And then depending on how the attorney I set up the structure,
Mhm.
that's how the attorney will file. Or not the attorney,
The accountant,
Accountant.
right?
yes.
Okay.
Yeah, no, you're exactly right. And, the S corp is really the main variable here. And, again, the reason for the S corp is to lower your liability when it comes to employment taxes, and that's the main reason why people will elect that S corp election. So, it can be very confusing. Tax is very confusing. There's a reason why I'm not smart enough to be a CPA, but it's just it's a lot to keep straight.
Thank you.
Clear as mud?
Yeah.
Clearer than when I came in.
Okay, that's good. I did want to talk on members. Sorry, Casey.
It's okay.
I do want to talk about easier to operate than a corporation real quick. So when it comes to an LLC versus a corporation, the most high level way I can put this is the IRS has rules built around both entities. Corporations have very clear lines when it comes to owners, how investors are, I don't want to use the word tax anymore, but how they are treated from an IRS perspective. LLCs are kind of like the Wild West. It's a lot more flexible, it's a little bit more fluid. Whatever you put in an operating agreement controls. That the operating agreement is the governing document that handles the management and operations and ownership of an LLC. C corporation, that document's known as the bylaws. High level, they're both the governing documents of its respective entity, but they intrinsically contain different language inside. When it comes to the operating agreement, North Carolina is the Wild West when it comes to operating agreements. It blows me away. Operating agreements can be verbal. So if we have an operating agreement today that we've drafted and we decide tomorrow that we want to modify it verbally, some of that language can modify the operating agreement. And so it's very important to set a precedent and a structure inside your entity that any revisions to an operating agreement are going to be done in writing. If you set precedents where there are verbal modifications, those may control. And so, North Carolina is pretty wild in that sense. So make sure that you're documenting membership, management, rights, responsibilities inside of an operating agreement.
And it really is clear as mud, because then you can bring in what's called extrinsic evidence when you're getting it in front of a judge, and who knows where that goes. And oftentimes a way that you can do this is to put a provision in the operating agreement that says all amendments or supplements to the operating agreement must be in writing and agreed upon by the members. So that'll cover you 99.9% of the time.
And we could expect an attorney to help draft those documents.
Yes.
Certainly.
Yes. I'd recommend an attorney draft those documents because, especially if they're more than one member, it becomes complicated as to who has what rights, and an attorney is going to, ethically usually cannot represent each member. They have to represent the company. They'll be able to tell you, okay, well, this is what this means. This is what this means, and you're able to come to a consensus.
Two of the pieces. Did you have another question?
No,
Keep them coming. I love it.
Yes.
Two of the pieces that I see get disputed the most when it comes to operating agreements. One is going to be, well, they're the same thing, but really it comes down to one owner being frustrated that another owner is not holding up their end of the bargain. And that can be in the form of capital contributions, which is the amount of money or equity, sweat equity, that is put into the business to get it started. And the other piece has to do with the duties and the responsibilities of each party. So if one party puts the money in and the other party does all the work to get it started, but it's not clearly delineated in writing that the other party's only going to put in money. They're not going to touch the business. They're just going to sit on the sidelines. But the other party is going to work 80 hours a week, and they're going to go to all the meetings, and they're going to go to all of the in-person events. The party who's putting in all of the time is going to get spent. And they're going to say, he only put in 10 grand. I could have done that, and I would be, I would own 100% of the profits. So I would say if you're going into business with someone, rip off the Band-Aid, that's time number 3, and have that conversation and just make sure that it's clearly delineated between both parties what the responsibilities are, who's putting in what and what duties are going to be down the road.
The more that's put in writing, the better, because it'll be as clear, instead of clear as mud, it'll be as clear as day.
And I'll say one thing I've learned is that this is not a form that's going to come up on the Secretary of State when you're, when you're actually registering your entity. So if you don't know about this form, you wouldn't have any reason to create it because it's not required by the state. And so that's why it is particularly helpful, I think, to go to an attorney for that, because otherwise you're going to be pulling a template from the internet that might not meet your needs.
Yeah, and if you don't have an operating agreement, the North Carolina general statutes have a statutory regime that governs how your LLC operates, and that's something typically you don't want to happen. You want to be able to have control over how your company operates.
All right, so we just talked about all the pros of LLCs. Now let's talk about a few of the cons. I'm not going to say the word tax again tonight, but that is one of the cons. We just talked about it. Yeah, I know. But we did talk about taxes. We talked about self-employment taxes. We talked about the benefits of S corps. So, I know we hear this on TV. We see it on YouTube, TikTok. We see it all over the place. People talk about Delaware entities often, and why Delaware? Delaware is nice because they have a chancery court that has litigated almost every issue that we could imagine, from almost every issue from a business perspective. My home state of South Carolina has a court that probably hasn't seen a tenth of the issues that Delaware Chancery Court has seen. So outside individuals, such as investors or banks, sometimes they prefer a Delaware entity because if things go south, they know that the law is likely going to be in favor of whichever party is choosing that Delaware entity. So if you're asking yourself, or if you see it on TV, or if you see it on an ad and they're pitching Delaware, that's a pro for Delaware. Their Chancery Court has seen a lot of business law. A con: who wants to travel to Delaware? Nobody. No one wants to travel to Delaware. So clients will come to me often. What's that?
You go through Delaware.
Yeah. You do not want to go to Delaware. When it comes to choosing Delaware, and I'm going off on a side tangent here, a lot of people will choose Delaware just because they heard it was great. However, Delaware is a bit more expensive to manage from an annual standpoint. And also, if you are drafting documents, let's say you're having AI draft documents for you, and you say, this document's governed by the laws of Delaware, and then you get sued or they sue you, you're going to have to go to Delaware and hire a Delaware attorney to fight that or litigate that on your behalf. Be very intentional when you're signing documents, whether they're non-disclosure agreements, which are very simple documents, from an execution standpoint. They're typically a page long or 2 pages long, and you may just say, oh, I'll sign this. But if for some reason they decide to sue you or you decide to sue them, you'll have to go to Delaware for that. So that's a little bit of a rabbit hole. But when it comes to going back to investors and lenders, they may prefer Delaware just from that perspective because it's easier to raise capital with a Delaware entity. The sidebar there is that, why are we talking about LLCs in Delaware? A con to an LLC may be that an investor would prefer you to be a C corporation. So on top of an investor preferring that you organize in Delaware, they may also prefer that you organize as a C corporation for the reasons that I talked about earlier, where it's easier for them to structure, based on IRS code that already exists, that we're not fitting a square peg into a round hole, the rights of investors in that C corporation. So I don't know if I'm losing you. I don't know. Okay, I'm seeing some nods. So that's one of the cons of an LLC. An LLC is great until you want to take institutional money. That's if we're going to leave with anything in the sense of cons. We have quite a few pros, but if you want to take institutional money from a big investor or some banks, they may require you to form an entity that's not an LLC. So.
Yes, ma'am, you had a question?
Yes, I'd like to direct my question to you, Andrew.
Sure.
Please. I want to go back to the limited liability. legally, of an LLC. As I understand it, the liability is limited in that the only thing someone could, if they sue you, what have you, or you have debts, or whatever, the only thing they are going to be able to attach, so to speak, is what's in the LLC, not your personal assets.
Right.
However, here's my question. Let's say you are generating a good deal of profit in your LLC. And you don't want that to keep building up so that just in case you do get sued, right?
Right.
They've got more to grab. Do you understand what I'm saying?
Yeah. So what?
So what do you do to kind of pass that profit through? Is there any
Sure.
hint
So
in that?
what you have in an agreement, in your operating agreement, is your right to make what are called distributions. So you're able. So for example, let's just, since I have an S corp, I'll use this example. So I pay myself a reasonable salary. Let's just say, I'm just going to throw a number out there, $10,000 a month. So but I'm making, hopefully I make more than $10,000 a month, right? So if you have excess in the company, you can take what are called distributions, and I would always make sure it's documented in the operating agreement, and that you do a resolution authorizing the distribution, so that way you can show that you're observing corporate formalities in doing this. Because where piercing the corporate veil comes into play is not only commingling of assets, but also failure to observe corporate formalities, and that's the one that that's the part that people don't know. That's the part that people get tripped up on. And I actually read a case, I think it was a couple months ago, about everything was commingled, or nothing was commingled, but they failed to observe corporate formalities. Therefore, the veil was pierced. So it is, and I guess that's the one point from the litigation aspect. If you can take anything away, no commingling of assets, follow all corporate formalities, so that way you can have that extra layer of liability protection that you basically paid for in creating your LLC.
So,
You have anything
I'm sorry,
else
quick
to add,
follow-up
John?
question.
Yes.
So then how are those distributions taxed? In other words, if I'm the member and I'm getting a distribution of $10,000 a month, how is that treated by the IRS?
So again,
As personal income?
LLCs have passed through taxation. So instead of paying double taxation at the corporate level and the personal level, you're just paying, it passes through to the members. So that way they're not paying taxes from the LLC's not paying taxes, and the members aren't paying taxes. It's just one. It's just the members paying taxes. I hope that I explained that okay.
So that would be an advantage, would it not?
Pass-through taxation is a major advantage of an LLC when you are looking at a smaller company. As Sean mentioned, it's the problem becomes when you scale up and you try to take institutional money, whether it be from private equity, an institutional investor, or even an institutional lender. They don't like LLCs because they want more formal governance, and they want and when Sean was talking about Delaware, which he made every great point there is to make, a lot of them want them in Delaware because there's certainty in the law. They have that chancery court that is so specialized with business attorneys that, as Sean says, they've seen everything in the book. They've created the book, to be quite honest with you. North Carolina has a business court that's been around for about 10 years?
Yeah.
So North Carolina's catching up. Texas has got a business court that they just started. So there are there are bodies of law in different states, but Delaware's always been the gold standard.
It's interesting, Andrew. There was recently a case decided in North Carolina Business Court where they relied on Delaware case law
Yes.
to decide how they were going to decide to rule. So
Yeah.
Delaware is the gold standard everywhere, and a lot of courts will point to them to decide how they're going to rule.
Yeah, I mean, they're very sharp up there. And I heard Dover is a wonderful place.
I don't want to know. All right. Corporations, Andrew.
All right, corporations. So we've gone through sole proprietorships. We've gone through LLCs. So what's the next step? Well, the next step is a corporation. So these are your Lowe's, your Home Depots, your McDonald's, these big companies that are these C Corps. So why would you create a C Corp without, given that you have so much flexibility with an LLC? Well, because you want a much more formal governance structure. Excuse me. So when a corporation is started, when you file articles of incorporation with the Secretary of State that you're forming in, or in Delaware it's called a certificate of incorporation, and that basically similar to an LLC, you have an organizer, and you have and depending on statute, you have certain things that need to be in those articles of incorporation. I'm not going to rattle those off because, quite frankly, I don't remember everything off the top of my head, and it's been a long day. But they are statutorily mandated that there are certain items that be in there, and the Secretary of State will not sign off on it until all of those are included. So what else is included with a C corporation? Well, a C corporation, as Sean said, you have bylaws instead of an operating agreement. That's what governs the company and how it's run. And then instead of members, you have shareholders. So, or in Delaware they call them stockholders. So how does all this fit in? Well, you have what's called a shareholders agreement, where the shareholders come together and they give certain rights to different shareholders. They may split up classifications of stock. There's a lot of different things that you can do with it. And it creates this governance that a lot of these institutional investors are, including creating a board of directors, which the board of directors are the people that run the company, and they may designate and they may delegate authority to officers like a CEO, president, treasurer. You have this. It's not completely unflexible in that you have to do things a certain way. You can structure a corporation, structure the governance of a corporation in multiple ways, and you can structure the stock or shares depending on what state you've incorporated in. You can make more classes than one class. But it gets to be very complicated. It gets to be very expensive. I've formed probably about 12 corporations in Delaware, and it can be quite complicated when you get down to the question of investors' rights and the question of shareholders' rights. So there are, as the slide points out, and I apologize for not checking emails. I'm trying to get the slides up. My computer likes to shut off after like 10 seconds. Thank you, battery saving. So C corporation. So this is the main issue with the C corporation is kind of what we just discussed, the double taxation. So you're taxed. So corporation has to pay taxes too, in addition to the individual shareholders that get taxed on their dividends. So you're talking about, instead of making distributions, you're creating dividends, which basically means, okay, well, you're giving the shareholders a percentage of profit that the board has determined is, that in their best judgment, the corporation can give to the shareholders. So you're getting taxed on both levels, and that creates a bit of a calamity, if you will, when it comes to trying to lessen your tax burden. And then with an S corporation, I think Sean's really covered that extremely well, so I'm not really going to get into that. A B corporation, which is something I've never formed, it has to be for public benefit. So it's got to have some societal components to it. Sean, have you ever formed one?
Not a B Corp, no. I was going to touch on nonprofits, which we typically will
Yeah.
form. I'll let you finish up.
No, please go ahead with nonprofits.
Yeah, so nonprofits, I'll talk specifically about North Carolina just because each state handles nonprofits differently. But in North Carolina, if you want to form a nonprofit, it's done in 2 steps. You file a articles of incorporation with the Secretary of State, and you actually file a corporation in North Carolina, which is very interesting to form a nonprofit. And then from there, once that's approved, you will file, I forget the form, I forget the exact form, but it's a nonprofit form with the IRS. And it's pretty in-depth, but they want to ensure that you are forming for a charitable purpose. So if you file the nonprofit corporation in North Carolina, and you do not file the IRS form, I'm blanking on the specific number, but you would not obtain nonprofit status depending on the form that you submit. Most people are going to submit a 501c3 exemption form. Once that's submitted, the IRS, they will review it. It typically takes 4 to 6 months is the current times that we're seeing. But what's nice is once they approve it, they'll actually backdate the approval to the original date that you submitted it, which is very nice. Now, if they don't approve it, they won't do that. But if it's approved, that's what they'll do. So, and one of the most important pieces of the nonprofit that I'll just touch on very lightly, you need to have a charitable purpose. There are, I forget the number, but it can be religious, it can be educational. There's an exemption where it's for the public good. If you have a charitable purpose, all the funds collected for and used under that nonprofit to be exempt need to be used for that charitable purpose. So,
Sure, and one last thing before we move on, as we mentioned earlier, your entity choice is not static. You can always what's called a conversion. So you can convert by filing certain documents with the Secretary of State from an LLC to a C corporation, if that's what you feel fits your needs the best. And then you would have have the documents prepared. You'd have to, I could get into all that you'd have to do, but it'd be outside the scope of this conversation. But all that to say is that, this is not a static exercise. This is something that you can continually make changes to.
I will touch on the formation of entities, which we've already touched on quite a bit. Probably my fault for skipping around, but when I go down a rabbit hole, I go. So when it comes to forming an entity, as the slides say, you can form the North Carolina LLC by filing the Articles of Organization. We also have the operating agreement up here. Again, as Andrew mentioned, it's not required, but it is recommended by both of us, everyone sitting up here. You need to decide whether the LLC is member or manager managed. So as we discussed earlier, the manager of the LLC is not always the member. So you could have is not always the same as the member. So the owner can say, I want this individual to manage the LLC for me day to day. And then that would be a manager managed LLC because the manager is separate of the member. The members could say, we want to streamline things and we just want to manage this LLC ourselves. We want to control the day-to-day operations of the entity ourselves. And that would be member managed. So that's the differences there. Initial filing fee is $125. There's a $3 fee if you use a credit card, it's $128. And then the annual report's $200 annually, and again, $3 fee there too.
$100 expedited fee as well. I would highly recommend you choose the expedited fee because I was not smart and did not because I was being cheap, and it took me 4 weeks to get my articles of organization back. And it's that $100 fee is 100% worth it. I recommend it. I actually bake it into my prices because I believe so strongly in getting this done.
Yeah, we do the same. They're slow right now. So, and then we touched on this. The corporation filed with the Articles of Incorporation and then the bylaws. So, Andrew, you care if I touch on maintaining?
Go for it.
Perfect. maintaining your entity. So, we've already talked about piercing the corporate veil. We've already talked about setting up your bank account separately. I told you I'm not a big credit card fan, but I highly recommend getting a credit card for your business. It just makes it easier to put everything on a credit card and hand that to your accountant at the end of the year and show them that those are the expenses solely under your business credit card and not under your individual name.
Hopefully get points.
Yeah, points are great. Yes, sir.
So what if you've already started the process that have not set up your LLC and purchased things through a personal credit card?
Not too late to start.
Yeah, not too late to start. Show your accountant.
Yep.
I mean, that's,
Okay. I've been documenting all this on an Excel file that all my expenses, receipts for everything so far for 25. So.
Your accountant can do some interesting and neat things in how they and how they set that up in terms of how it's taxed. I mean, I'm not going to get into it, but
I was thinking more of the veil that you were talking about, like being able to penetrate the veil.
well, and that also will help. I mean, have you set up your LLC yet?
No.
There wouldn't be any veil to penetrate yet.
Okay.
So there's not, so that it's not something, what you would be more concerned about is once you set up your entity, how those expenses are treated in terms of taxation. And I'm from a family full of CPAs. My father-in-law is a CPA, and I'm the quote unquote black sheep of the family, in that I did not go that route. I'm a lawyer instead, and I've got the big mouth. But essentially, they're going to be able to help you out in structuring how those work out tax-wise to make it most beneficial for you and your company.
Yes, ma'am.
So, the concept of you can change your mind later with what
Sure.
system you want to start. So,
Right.
if you're starting with a sole proprietorship and then, 2 years later, 1 year later maybe, then you think, okay, this makes sense to start the LLC process.
Mm-hmm.
But, it could be like 2 or 3 years past. I mean, are there things that you should be doing while you're a sole proprietor, like just in case? Like if you're operating as a sole proprietor and you don't have, your separate like LLC accounts and that sort of thing, I mean, should you at least, I guess, like open a separate personal checking account and have all of your stuff going through there, or is it just
It really wouldn't matter, because banks are going to require you to get the EIN, the employer identification number, before you can open up a separate account in the name of your business. So let's just say, I've got, Andrew's birthday party, extravaganza that I do business as, and I, do the what do they call the balloon thing that the clowns do for kids. I only say this because my son just went to a birthday party and he really just had a ball with that. But in any event, let's just say I do that on my own. I don't have an LLC. Well, no bank is going to allow me to open up an account in Andrew's birthday extravaganza, because technically it doesn't exist. So I understand what you're saying, but until the entity is formed, there's not really any steps necessarily to take. I don't know if you agree with that.
Yeah, there's not much you can do, but I would ask the question, why haven't you formed yet? And it may just be time, but I would advise, if you are engaging in business and your risk tolerance is low and the liability of what you're engaging in is high, it's probably worth the time to set up the entity.
Mm-hmm.
So.
And then just a quick follow-up question. So I thought as a sole proprietor, you could get an EIN number, even though you don't need to?
You can.
You could, okay.
Yeah.
And then I guess you could open up a sole proprietor account with that?
I'll be honest with you. I think that's more tax advantageous than legal.
Yeah.
Most attorneys probably aren't going to be involved or touch that because there's no liability protection.
Right.
And so, you can get an EIN for your sole prop, but that's typically not something that an attorney would advise.
Right. That's more of a banking question, because different banks are going to have different requirements. Most banks that I've encountered in my practice, which again, people are coming to us because they want something formed. So that's not really a question that we have to address. But they're going to want to see the articles of organization or incorporation, and they're going to want to see the EIN, and they're going to want a manager or managing member or someone who has authority to bind the company to sign the authorization opening the account.
So we talked about keeping your business funds separate from your personal funds. Let's talk about signing contracts and how you do that in the name of an LLC. So quick story, it's a real story. I have a client who executed a franchise agreement in her personal name because her LLC wasn't set up yet. And so she executed the franchise agreement, which is 200 pages long and it says a lot. And she just said, I'll do this now and then I'll set up everything in the business name later. Things went south.
That's going to be good.
Yeah. Things went south, hence why I'm involved. And the franchise agreement is now being litigated, and it's being litigated in her personal name. So all of her personal assets are now exposed because even though she ran the business in the name, of her business, set up the LLC, set up the bank account, got the credit cards, all that happened after she signed the franchise agreement in her personal name. Now, under contract law, she's being sued individually. So, when it comes to executing documents, it's very imperative to make sure that you're executing them solely in the name of the business, not jointly in your name with the business's name as well, only in the name of the business. Our best practice internally as a firm, we go to the Secretary of State's website for every single client that we draft documents for on both sides, and we copy the name of the entity from the Secretary of State's website. Why do we do that? Because sometimes, and I'll take Garrett, PLLC for example, sometimes there will be entities that are Garrett, no comma, PLLC, so just Garrett PLLC, no comma. The PLLC may have dots in between it, so P period, L period, and it gets hyper nuanced. The best practice is to actually use what's on the Secretary of State's website. However you form your entity, make sure that if someone sends you a document, whether it's as small as an NDA or as complex as an international business agreement, make sure that you're executing it in the name of your specific business. I would even advise, it may seem extra, but at the end, add a North Carolina limited liability company, because you don't want to be confused with another entity. There could be your same entity name in Texas, and you want to ensure best practices that you're identifying your entity specifically. And at the bottom, this is probably a bit of a rabbit hole as well, but you want to ensure that you're signing as a member or manager of the entity. You do not want to sign at the bottom in your personal name, because even at the top where it says we're engaging in contract with your entity and you sign your personal name, there could still be an argument that you're signing that document personally. So,
What about a DBA?
Yeah, good question. If you sign as a DBA, I don't love DBAs. I
don't
like
either.
them. I like them in the name of LLCs. I would probably recommend having Garrett, PLLC, DBA, whatever the name is of the DBA, because to your point earlier that we were discussing, if you set up a DBA and an EIN, you could operate that as a sole proprietorship, and that would allow pass-through liability to your personal assets. So we don't want to do that. So whatever entity you form, LLC, corporation, make sure that specifically is on the name of the document, not the DBA. DBA can join, but we want your entity.
The only time that you really should be signing individually is if in a lending situation, if they require, and I don't mean to get ahead of you, Sean, but if they require a personal guarantee. And I would, the slide says avoid personal guarantees. Absolutely avoid them. Avoid them, but sometimes they're going to be unavoidable. So that's really the only time that you should be signing it on behalf of your own name, is if you're signing a personal guarantee.
Yeah, I really wanted to hammer that home. Personal guarantees, what is it? It says that if the business's assets are not significant enough to offset any debts or liabilities the business owes, you are personally signing on to that loan, debt, agreement, whatever it is, saying that you'll offset it with your assets. It's extremely important. Clients will sign documents often, all day, every day, not realizing that they're signing personal guarantees. North Carolina is a good state in the sense that they require attorneys to be involved in most loans that take place. However, sometimes lenders will get by stating, we've got an attorney here, ask them questions, but they're hired by the bank and they're not really working on your behalf. And
Right.
so a lot of times you're going to sign, where's my check, move on, and then 2-3 years down the road, they'll say, hey, there's a personal guarantee in place, and you'll say, I don't even know what that is. And so I would say, no matter how big the loan is, I would really get someone involved to review the documents. Yes, ma'am.
So when you just said that, that the lenders, they say, hey, this attorney is here to represent you. If you don't use this attorney, then you can't proceed. However, that attorney's office sends you an engagement that they're representing you. And the lender is now saying, oh, they're working in your best interest.
That's a good question. If they engage you, I don't think there's as much of a concern there. Now, if you are skeptical, get your own attorney.
Right.
I would say, most lenders are not going to say, we won't issue the loan unless you use this attorney, because there are a lot of predatory lending laws that prohibit that.
Conflict of interest law.
Yeah,
too.
conflict of interest laws. There's a number of laws that would keep that from happening. But if they strongly advise, sometimes lenders will say, if you use our preferred relationship, we'll give you a discount, which happens a lot.
Right.
And in your circumstances, Google reviews, look them up on Justia, just different platforms to figure out who this attorney is and see if you can trust them. But if they send you an engagement agreement, I would have some confidence there.
Yeah, and make sure, have a conversation. It's important to, when you get into this attorney-client relationship, it's important to have that trust. So make sure that, he or her, whomever you engage, that you have a conversation with them so that way you can have that trust, because I can tell you from the attorney end, it doesn't work if I don't have trust from the client. It just does not. And I've become very, not necessarily very, but I've become selective in who I represent, because I want to make sure that we have that trust at least from the get-go, so that way, not every decision is questioned, or not all my advice is necessarily questioned, and we have that symbiotic relationship to where they can ask me questions and trust the feedback that they're getting.
Okay, and that you are locked in to their best interests.
That is our ethical duty, is to, if someone engages us, we have to act and, advise them on in their best interest. But at the same time, I tell my clients this all the time. My client's the captain. I'm just the first mate. I can help plot the course, but I'm not making the decisions. The client is always making the decisions. I do not make the decisions for them. So that's an important distinction to understand when you're engaging an attorney.
So you're actually going to kind of comb through the essential documents to make sure they're not signing away their left toe and their right kidney and their
Right. So I explain what's in the documents, and oftentimes, I've represented companies in several loan situations where they're trying to obtain a loan, and I will redline the document. I will say, okay, well, this doesn't make sense given your business model. This needs to be changed. This wording needs to be changed, and I'll suggest changes. And you submit it back, client reviews it, agrees with it, submit it back to the bank, and the bank has their say as to what they will agree with and what they won't agree with. That's typically how that process works, and I assume it's probably been the same in your practice as well.
Yeah, I agree.
I think to your question, though, the attorney isn't necessarily going to say, you should not give away X, Y, and Z in order
Right.
to take this on. their role really is going to be to advise you what you will potentially be exposing if you take it on, and then it's kind of up to you as the business owner to make that
Great
choice,
point.
which is what sort of you were getting at.
Yep, great point. Yep, it's just advising you on what is there and what this means to you. Whether you decide it's in your best interest to take that on, that is a perfectly, most likely, very reasonable decision. But that decision just rests solely with you.
I would say, growing up, I didn't know a lot of lawyers. And so getting into the legal industry, I had to determine what is the marker of a good attorney. And Andrew and I both do this when we're talking to clients. A good attorney is someone who's going to make you understand the documents. We're not
Right.
going to say, do or do not sign that. Sometimes I'll tell my client, don't sign that. That's just not
Yeah.
But most of the time, we're going to say, this is what this document means. Let's talk through it. Do you have questions on what a personal guarantee is? Let's talk through what is being exposed from your personal assets if you sign this document. Sometimes I ask my clients, repeat this back to me. We work on business buy sells quite a bit, and we get into complex documents. And I see my clients' eyes glazing over, and I'll say, what did that mean to you? And sometimes they'll say, I don't know. And so we'll get a little bit more in depth, but make sure that in any representation you understand what you're signing. Just because they tell you the word indemnification or rep and warranty and they tell you sign right here, that's not good enough because you didn't understand it. They need to allow you or help you understand the documents.
And to that point, I mean, you're making, if a rep and warranty, you're making representations on your behalf that something is happening or something has happened. And if it hasn't, it doesn't matter whether you understand it or not, you're in breach of that agreement, which means that they can put you in default and they can use whatever remedies are in the document to proceed against you. So it's really, really, really important to have someone like Sean who can explain the documents to you in layman's terms, and that you have a complete understanding of what you're signing.
Or Andrew. He's selling himself short. All right. Cognizant of time, we have a lot of slides to go through. Are there any questions? I know we've done a good job asking questions. Anything that's come up in the meantime that you guys want to pivot to, talk through? Hearing none, feel free to interrupt us. Andrew, I think I took the last one. You wanna
All
go?
right, multiple owners. So we've kind of danced around this a little bit earlier. We talked about there being multiple members, multiple shareholders. Talked about shareholders agreements. So what are some things you think about before founding a company with someone else, whether it be your spouse, your friend, just a business contact, or you bring somebody else in later? Well, number one, what is the business going to look like looking forward? Who's going to have control? Who's going to have say? Sean brought up the example earlier of someone paying 10 grand into the company and then the other person working 80 hours a week and putting in all this sweat equity to get the company up and running. Well, that's a recipe for disaster. So you want to understand what it's going to look like moving forward in terms of who's going to have who has what role, and both people agree to it. So and then what will the ownership split be? Are you going to do it 50-50? Or is someone going to carry more of an ownership split because they're taking on more risk, which is typically why you would do that, is if somebody puts up more capital, or if somebody is working in this 80-20 situation that Sean explained. If someone's putting a lot of sweat equity into it, they're probably going to want more capital if they're going to be doing all the work. But that's all a question of bargaining power when you start out. And it's important to memorialize that and to get an understanding between both parties as to what that means from the outset. So how is each owner investing up front? As we just said, it could be capital. We call it capital contribution. So what is a capital contribution? This is what you are injecting into the company to help it start. It could be cash. It could be property. It could be sweat equity, or, it could be, getting, I guess sweat equity is probably the best way to describe it, and you actually doing the work to get the company up and running. I have put that in as capital. I have put all kinds of different things in as capital contributions to operating agreements, or which is typically where you will find these. And then income and salary to be paid out. How is that going to be paid out? Well, we talked about distributions, we talked about dividends, we talked about S corp elections, but that's not all. You could classify yourself. Is someone going to be classified as an employee of the company, where you have to issue a W-2? Is someone going to be, what is that going to look like? Is someone going to draw a salary? That's something that all should be discussed from the outset. Split of duties, I think we've covered that. Owner's rights. So owner's rights this is probably the most important thing that we're going to discuss on this slide. So owner's rights include, when you're talking about owner's rights, you're usually talking about control of the company, control of the decision making. So Sean discussed earlier a member and a manager. So in an operating agreement, you can delegate certain tasks for lack of a better term, to the manager. So who's going to be the manager of the company, and what task does the manager have if the manager is also one of the owners of the company? Alternatively, you can have two people and say, okay, well, we're going to manage this together. We're going to both be managers, or we're going to just say that it's member managed, and we're both going to manage it together. Well, is there going to be what we call a deadlock provision, in that, what is going to happen in the event that if you both have 50-50 power, can't agree on something? And it's in what context do you need that deadlock provision? Is it a major decision? Is it an everyday decision? All of that needs to be spelled out in the operating agreement. It's all something that you should be thinking about whenever you're starting your company. And then lastly, if there are expenses, what percentage of funds will each person have to put further into the business? So these are called capital calls. So you have your capital contributions, but let's just say, okay, you get hit with a big speed bump. This is a $10,000 hurdle that you have to overcome. How is that going to come about? Well, typically you'll have a provision in your operating agreement, and again, I'm talking about this mostly for LLCs, in that it will say, essentially, in the event that the company needs more capital, the company is going to call for more capital, usually in what we call pro rata percentages. So that will equate to the percentage of the company that you own is how much you're going to have to put in. So let's just say, for simplicity's sake, 50-50, and it's a $10,000 hurdle. Well, each member is going to have to, put in $5,000, or there will be a provision in the operating agreement that says, okay, well, if you don't do this, then this is going to happen. Sometimes it may be deemed to be a loan to the other member of the company. Sometimes the other member will have the opportunity to make that capital contribution, and in return get a piece of that person's equity in the company. So there's always a stick to the carrot, or there should be a stick to the carrot in the agreement, and you want to make sure that all of that is something that you're thinking through, that you work out in the beginning, that you have documented in this agreement, so that way there are no questions when it comes to it, and it's all a matter, as Sean has pointed out, of contractual interpretation. And if it's a matter of contractual interpretation and it's in the document, then you're in a much better position than you would be otherwise.
Yep. One thing I'll touch on before we switch to contracts. certain provisions that I like putting in operating agreements, and I like that Andrew pointed out. We focus on LLCs in conversations like this just because the majority of our clients that are small businesses form LLCs. So we're looking at this through the LLC lens, but I call them the 4Ds: death, disability, and divorce, alongside deadlocks. So I'll take deadlocks by themselves. Deadlocks are, if you're two owners, how do you decide, and you're 50-50 owners, how do you decide how to move forward with the decision? Sometimes what I've built into operating agreements, we'll get creative. Maybe there's a key employee or someone that they both trust. A CPA would not recommend your attorney. They can't, actually. But I would recommend someone that you both trust to decide deadlocks. So if that pops up, just think through, how are you going to decide? Maybe you say, well, flip a coin. Put that in the operating agreement. But how are you going to decide if you disagree? How do you move forward? And then 3 provisions that I put in, the other, the death, disability, and divorce. When it comes to buying back someone's interest, that's extremely important, especially when it comes to automatic buybacks. I'll take divorce for an example, and I'm not going to go too deep into these just for time, but I will typically build into my operating agreements with my client's permission that divorce is an automatic trigger for a repurchase of interest, because we do not want to allow an entity to enter divorce court. So if there's a divorce contemplated, let's say you're an owner and you've got a co-owner, and your co-owner is going through a divorce, well, you really don't want to become an owner with their spouse, potentially. And so putting in a mandatory buyback or a first right of refusal from the company for their interest, that's typically what I build in. Death or disability, I really have the clients have that conversation. Sometimes they want their interest in the business to pass to their heirs. Sometimes it makes sense to have insurance in place if they were to pass away, to automatically buy their interest back. So just 4 considerations there. We'll pop over to the next one. Contracts. This is where Andrew and I really shine. Contracts. So I want to rethink, I want to talk through rethinking the contract from legalese, just words on a piece of paper, to an actual roadmap for the relationship, whatever it is. I like drafting service agreements, so I'll take that as an example. Let's say you're offering a service to a client. A master service agreement, as it's called, an MSA, or simply just put, a service agreement, will determine all of the important aspects of the relationship. What are you doing? How much are you making? When is it due by? Who's going to produce it? And there's all sorts of legalese that you can get into with your lawyer, but I would rethink that agreement rather than just a road bump, or a speed bump, I guess you should call it, to the actual roadmap with how you're going to deliver those services and how you're going to get paid. Because that's very important. You need to know how you're going to get paid, how long is it going to take them to make payment after you've delivered or performed the services. And so there's a lot of important provisions in there when it comes to these contracts. I would not consider them a formality. I would consider them your roadmap.
Absolutely. Same with supply contracts, which is mostly applies in a distribution sense. Contracts are extremely essential because, as Sean just pointed out, they are your roadmap for how you're getting paid, for the time frames that you're providing goods and services, and what happens if something goes wrong should be in the contract as well. And there's a ton of provisions that Sean and I could go for days on contracts. Mm-hmm. But it's just it's very important to approach those as you would when you form a business, because you're essentially, this is your roadmap for your relationship, and so I would approach it with the same vigor that you would approach starting your business.
So I'm going to run through these questions real quick, just to get our minds and brains flowing on what contracts should and can entail. What is this for? What's the contract for? Services, goods, are you selling socks, and is that controlling the relationship? Why are we forming this contract? Who are the parties to the contract? Remember, it's always going to be your entity, hopefully. How long are we engaging in this contract for? What are each party's obligations? We're going to dive into that one in a second. How is risk allocated? and how much does it cost? How much are you being paid for your services? Due to time, I did want to touch on what are each party's obligations. I recently drafted a lease for a client. It's a templated lease that we've worked on numerous occasions, but it is it was redlined, and it came back to him, and there was a line in it that said, the landlord will indemnify, big word, protect the tenant from any liability that the tenant runs into on behalf of the landlord. Such a broad term. I told my client, that is shifting all of the risk of business, life, all the above to you. And so we had a conversation, risk tolerance, to determine if that's something that we really want to engage in, because that shifts the obligations that he owes to that tenant tremendously. For most other tenants, one of the examples that we talked about was if someone were to, let's say that someone was cutting the grass and a rock flew through the window. Well, in most of the other tenants' leases, it just said that that is an act of God. That's something that a third party engaged in, and so insurance would handle it, or the tenant would handle it themselves, or the mowing contractor is responsible for it. Based on the language that tenant put in, the landlord would be responsible for that no matter what. And so when it comes to these contracts, really read through them. One sentence changed the entire relationship of that landlord and tenant in that scenario. And it's just, had he not realized it, had he read through it and said, nah, it's big words, I really don't want to deal with it, I'm just going to sign this, it could have held him to some pretty extensive terms down the road. So,
Beautiful example. That was awesome. Oh man, as a guy, I mean, I've represented both landlords and tenants in commercial settings, and I do more landlord work, and that is chilling. Man. So who are the parties to the contract? I think we've really gone over a lot of this, but typically if you're an LLC, if you're an entity that is not a sole proprietorship, it should be your company. And as the slide says, you can add a DBA, but just because you sell your stuff as as Fran's, I guess you can say Fran's Eggs or Fran's Farm Fresh Eggs. If it's Fran Incorporated, Fran's Farm Fresh Eggs doesn't exist. So you want to sign as Fran's Incorporated. And I literally pulled that one out of the air. But
I like it.
it's been a day. But yeah, so, and then as Sean mentioned earlier, you want to make sure that the name that you sign with matches what's on the Secretary of State's website, because that is your legal name. Mm-hmm. And that, I mean, copy and pasting is genius. You wouldn't think about it because you're like, oh, well, it's so simplistic. That's like, a first grader can do that. But sometimes sometimes it's something that rudimentary that can really affect the entire contract. So that's a great example, a great tip. I would use that.
Yeah, I agree with you, Andrew. There's an example on the screen if you want to run through that.
Sure. So exclusive supply and distribution contract. JH Solutions Incorporated, a North Carolina corporation. And you got ET Solutions LLC, a Delaware limited liability company. So Sean touched on this earlier. Why do we put a North Carolina corporation? Why do we put a Delaware limited liability company? Well, because there could be more JH Solutions Incorporated out there. There could be one in Texas, Alabama, Louisiana, somewhere else. And you wanted to know, and you want to make sure not only that you put that your company is well represented on this and correctly represented on this, but you want to make sure the other side is too, because if you sue them, then JH Solutions, a Texas company or a Texas corporation, well, they're not a party to the, they're technically a party to the contract, but they may not have any assets. So there may be nothing to sue. So that it can get super technical, but you want to make sure that that the names of both parties align to what is actually out there in the public record.
And in this example, one of the parties describes itself as its company name and its
I was
affiliates.
just gonna
Yeah.
touch on
Yeah.
that. Yeah. Go ahead.
No, you go ahead.
Okay. Well, I was gonna say, I recently had a seller client, and for some reason, the buy side client put in that language and its affiliates. And I know what it means, and we'll use it on occasion if there's a contract that should be assignable. But if you're selling your business, you do not want a contract that's assignable. And so, and this isn't necessarily assignability, but it has to do with affiliates, which the definition of affiliates could be broad. It could be someone that you're affiliated with, someone that you do business with. And so my question there, if you were executing this contract and you put in and its affiliates, are you extending liability too great? Are you extending liability unnecessarily, or are you even able to extend that liability? And then when it comes to if they're on the other side of it, if there's someone else on the other side of that contract that you are hiring for a specific use case, do you want someone else to perform the services or goods that you are contracting for? And so making it very simply put, if and its affiliates is seen there, or if it's on a contract, you may not, a year down the road, be doing business with whoever is on the other side of that contract, if
Right.
and its affiliates is listed, because they could easily say, they're one of our affiliates and they're listed here. So I would say that's language that I would not incorporate
No.
without intent.
No, and if you see that incorporated into the contract, question it, and if there is pushback and it has to get done, have it defined. What is an affiliate? Who is an affiliate? Is it JH Solutions LLC, a Texas limited liability company, or is it someone else? We as lawyers, and this is going off a little bit on a tangent, but we want to define everything. And there's a reason why we want to define everything. We want to create as much contractual certainty as we can. And that is, I've got clients that have asked me, well, why is this in there? Like, why did you take this took you another 5 minutes to do this? Like, why did you do this? I'm like, well, because if it's not defined, then we don't know what it is. It's exactly subject to interpretation, and when you put it in front of a judge, they may think differently than you do. So it is so important to define these key terms, and that would include and its affiliates. You'd want to know who its affiliates are. So great point in bringing that up.
Yeah. So at this point, I would love to shift this over to Casey. Casey runs a phenomenal nonprofit that assists businesses in the early stages of their business, and I would love to have Casey describe Climb and what they can do for you if you fall into their box for legal services. Yes, ma'am.
I just had a quick question on one of the last slides
Yeah,
that
which
you
one?
had up. I'm not
Nope.
sure. Just the
Whoops.
one where it's like,
That's,
we don't need the slide. It was just the one
Okay.
where it's like never signed in your name.
Yeah.
Unless you're a sole proprietor, in which case you have nothing else to sign.
Yep.
Sure.
Right. So, is there, even if you're a sole proprietor, like, should you always have a contract? Like, if you're a consultant, for example, like, should you have would you recommend having a written contract that you do sign with your name?
Absolutely.
100%.
Absolutely. You should if you are providing services for somebody, especially in that kind of a capacity, or providing goods for somebody, you should always have a contract. And why? Because the contract will govern the relationship, and you know exactly who is obligated to do what. So I'm obligated to provide legal services to XYZ Corporation, and XYZ Corporation is obligated to pay me, X and X amount of dollars in return for my legal services. That's not a good example, but just I guess as an abstract example, that's something that you want spelled out.
Do you want to spend 5 minutes on some of these
Yeah.
ones that I think trick people up?
We're gonna have time for questions?
Yeah.
Yes.
Yeah.
Okay, should I ask it now?
Yeah.
Please.
Yeah, so, given that if you're a small business, what are some things that you suggest for protecting yourself when you're working with the larger corporations and you're doing business with them? Particularly sometimes when they're banking on that you don't have protection, like what might you do very much early stage? The other part of my question are, what are red flags when you're hiring a lawyer? And also, what are some green flags? And also things that are nuanced, like things you're like, ooh, I feel something, let me run in the other direction. So, all of those.
So addressing your first question, I've worked with multi-billion-dollar corporations and I've worked with small companies. It isn't. I put everybody on a level playing field, because at the end of the day, the contract is the contract, and that is. I mean, I approach every problem the same way, and making sure that we understand what the obligations and rights are, and we understand the balance of the relationship, because it doesn't matter whether you're dealing with Walmart or whether you're dealing with mom and pop store on Main Street. That contract's going to govern. So I would not necessarily be intimidated by just because you're working with a Walmart or a big corporation like that. I would approach it just like you would any potential business relationship. And what was your second question?
Because I think the thing for me is like when you have a whole team of lawyers that you can wear people out with and time. I'm even thinking about accounting, all that kind of stuff. Like
Sure.
Banking on you not having the money to fight them. So that's what I'll say.
Can I touch on that?
Yeah.
I heard a very smart attorney in Western North Carolina say this the other day, and I loved it. He said the most dangerous lawyer is the lawyer with one file on their desk. So if you think about those big corporations, they're going to have client after client after client that they have to email, stay up late, and resolve. They want to get this done because they've got another major client behind them. When you've got someone that is local, maybe smaller, less clients, they're going to, one, have a very invested impact in you and your business because they live here. If something doesn't work out in your favor, that is likely going to reflect on them. And so they're going to fight tooth and nail for you. Personally, I love the big guys. We go up against them all the time, and have had, no guarantee of success, favorable results.
Cannot be guaranteed.
Exactly,
Nope.
cannot be guaranteed.
Nope.
For that reason. And my experience has been, a lot of times the attorneys on the other side are going to say, Sean, let's just resolve this. Let's get this figured out.
Yep.
I've heard that time and time again. And my clients, typically smaller businesses, will say, well, it's the fact of the matter. The fact of the matter is probably the best way to put it. They want to prove a point, and at some point I have to tell them, this is probably the best result we're going to get given the circumstances. So
You can be a fly in the ointment to a lot of these big corporations, and that they're moving commerce. Like they want to get these deals done and then move on to the next one. So I would not be intimidated. Just don't go in with a mindset just because they have billions in EBITDA that they're going to be any better or worse than in negotiating than mom and pop store down on Main Street. So just don't be intimidated.
your second question, red flags and green flags. I love that question. I've never been asked that before, but I think it's something interesting to consider. I think green flags for an attorney are going to be, number one, like I said earlier, translating legalese. And it doesn't always work because sometimes I was meeting with a client legitimately today where I said the term USPTO, and he said, what's that? And I said, oh, I forgot, that's not something that you're familiar with, the U.S. Patent and Trademark Office. And so I do have to catch myself. But if you're talking to an attorney that's not willing to go back and explain some of those provisions, and they're just trying to get you to sign a document, that's a red flag. That's my first one.
You want to find somebody that listens. You don't want to find somebody who's going to pontificate a solution. You want to find somebody who's going to listen to your problem and is going to, sometimes I repeat it back because I want to make sure that I understand what I'm being asked, which is, similar to asking you to repeat your question. I want to make sure I can adequately address the question, because if I'm not in a position that I can, let's just say, it's an intellectual property issue. I don't deal with intellectual property. The specialists deal with that. Then I'm going to send it to an intellectual property attorney so that way you can get the best service possible and you don't have me rambling on for 30 minutes and not knowing what I'm talking about. So you want to find somebody that listens.
Another red flag, go to their website and look at their practice areas. If you see real estate, family law, intellectual property, criminal defense, you're probably going to get a jack of all trades. And that's not a negative per se, but if you want to resolve a matter efficiently, I would recommend getting with someone who focuses. I'd love to see 2 to 3 practice areas that are hyper-focused. If you click on a practice area and it has 10 other practice areas under it, that's probably too much of a generalization to resolve your matter efficiently. They'll probably get it resolved. It may take a lot of time, may take a lot of money.
I agree. And I know people who are jack of all trades who do a great job and do a great service. But if you have a nuanced problem, it is more cost efficient and very effective to go to someone who handles that on a daily basis, because they've seen it. They understand the case law. They understand what can come out of this contractual provision that you don't want. And I guess another red flag is I guess I go back to my last point in that someone who pontificates a solution without you even saying anything. Let's just say you have an inquiry that you pose to a chat bot, and you get an appointment, and they said, okay, well I've read what you posted on my website. Here's what we need to do. No, a consultation should be something. It should be your first step, and they should have an understanding of what you're going to come in and say. But they should, as I said earlier, they should be listening to you. They should be understanding what the problem is, because oftentimes the best solutions are the most pragmatic solutions. And you want to find somebody who's going to have that kind of understanding and creating that pragmatic solution.
I do want to jump on the screen and talk through some of these that Casey astutely pointed out. Andrew, I'll take a few of them, and I'll let you take a few.
Sounds good.
Some provisions in a contract that need to be addressed. How do we get paid? That's important. On top of that, it's when do we get paid? If you're dealing with a services contract, sometimes you need funds up front to get started. The question is if you need to purchase something specific for that service or for the goods, whichever it may be, is that laid out ahead of time, and is that clearly delineated to the client? I'm not going to go down my rabbit hole. My head is spinning. Are fees and taxes included? When do you pay? It's already there. Good job, Casey. Can you increase the price for any amount and for any reason? Let's say change in circumstances. I drafted a contract for a client. They didn't follow it like a roadmap, and so things went south. But extra material needed to be delivered for a project, and the client will not pay for the extra material to the tune of 5 figures. It's a lot of material. And so right now we're going back and forth trying to determine how to get paid for that, because they are unjustly enriched. They have $40,000 of product that they shouldn't have, and the question is, how do we get reimbursed for that?
See that a lot. I'm sorry, Sean. You see that a lot in the construction space. You also saw it a lot with tariffs. So tariffs come in, costs increase. Who does that get passed off to? Is it the supplier? Is it the manufacturer? Is it the consumer? Typically, it's the consumer. But the question becomes, before it gets to the consumer, who pays for what? Mm-hmm. And that was, something that was really important when those were, especially when those were starting to get ramped up and getting put into place.
What happens with late payments? Can you charge a late fee if it's not in there? Maybe not. I'm going to go down to the bottom one, and then I'll hit one more and pass it off to Andrew. Force majeure. That is a provision that you'll see in a lot of contracts that says acts of God. You will now see if a pandemic occurs that did not occur, that was not built in prior to 2020. But if something happens that prevents you from performing your liability or your obligations under the contract, what happens? A lot of times there's going to be a stay or a delay of the services until the force majeure event is over. And I highly recommend we build them into the majority of our contracts, just because if you're performing a service, you don't want to lose out on those funds, but maybe you can't leave. Maybe the government's saying you cannot leave your home. So
Right.
very important provision. And then up to the green real quick, I'll let Andrew take purple and yellow. How is risk allocated? We touched on reps and warranties and covenants a little bit, but I would think about that kind of like my my landlord-client example. The tenant's trying to slide risk to him. We don't want to embrace any risk. We want you to have all the risk if something happens to us. So when you're reading through these contracts or if you're engaging with counsel, make sure you're asking the question, how can I be sued under this contract? I think that's a nice broad question to ask. And probably challenge your attorney. They're going to say, "Who have you been talking to?" And then they'll give you that answer.
Drop
there.
his name. They'll get scared immediately. All right, limitations of liability. So restrict the amount or type of damages that one party can recover from another. So you can have caps. You can cap your damages off at a certain amount. Let's just say like a year's worth of services is something I see often, or a certain amount of period of time of services is what I see often, and how damages are capped. Limiting secondary losses. So this comes up both in real estate contracts and in commercial contracts. So in a real estate lease, a landlord typically has a duty, what's called a duty to mitigate. So they have to go find, or they have a duty to find another tenant, and basically try to cut their losses. And then in the commercial context, you look at this as what we call cover damages. So let's just say, for example, I manufacture, or I'm a semiconductor, not manufacturer, but that's what I design. And I send the designs over to a manufacturer to manufacture. Well, manufacturer says, all right, well, you can go fly a kite because I found a bigger business, and I don't want to deal with your contract anymore. So what is a cover damages are where the semiconductor goes to another manufacturer and pays them to manufacture the semiconductors, and then they've mitigated their losses, and then it becomes a question of, okay, well, if I've covered, then I had to pay X amount more. Well, you owe me X amount because you breached the contract. And then indemnification. This is extremely important. So this is a concept that one party will compensate the other if a certain loss occurs. So typically, you see this if somebody gets sued for something that the other party did, then that other party who's not getting sued would have to pay for the lawsuit, the expenses that come out of the lawsuit that the party getting sued is paid. I know it's kind of a word salad, but you want to make sure that you protect yourself from being unfairly blamed or sued for something that's completely out of your control. So negligence on the part of the other party. If you get sued, let's just say, for example, Karen's making socks, and then I distribute the socks. Well, if Karen's making the socks and there's something defective about the socks, shouldn't she, and I get sued because there's something defective with the socks as the distributor, well, shouldn't she have to cover the damages since she made the socks? That's kind of that's pretty much the concept of what we'd be looking at.
So I'm going to just take a few minutes. I'll probably skip the slides and just show you my information. And I'll just talk to you briefly about what Climb is. That's my organization. So you may have heard of an organization like Legal Aid of North Carolina or Charlotte Center for Legal Advocacy. And what they do is they represent people who can't afford attorneys in things like, say, you're being evicted from your apartment or something like that. Before Climb, though, there really wasn't anywhere to go if you were trying to get a business off the ground and you didn't have access to an attorney. Before Climb, there wasn't anywhere to go. And so at the same time, you have all these banks, all these large multinational corporations here in Charlotte, and there are many very large law firms that are set up here, headquartered here, operating out of here to serve those large companies. And for a variety of reasons, law firms that work for those big firms want to do pro bono. And so Climb exists as a way for those lawyers to offer their services pro bono to small businesses that can't afford them. The kind of work that we do, pro bono, which means free, is transactional legal assistance, which is basically helping you create documents, create contracts, review contracts, like preventative legal care, which is different from litigation, which is where you're in dispute, you're arguing. We can't help with that. But really, there is no organization that's going to help a small business completely free of charge if you get into a dispute with a customer, with another business, with a landlord. And so we exist to try to create sound structures that can help you thrive so that you don't get into those kinds of conflicts that can become really expensive, to the extent possible. So we can help to draft contracts, review those loan documents, review a contract that you're already a party to that you might be questioning now, set up your LLC, form an operating agreement, create investor agreements, some intellectual property work, things like that. And so the way that we do that is you apply through us for services. We talk to you, help figure out what you need, and then we send you to a law firm and you become a pro bono client of the law firm to help you with whatever it is that you've identified as needing. If you are ineligible for services, I always recommend people just apply, because I have the good fortune of knowing many, many members of the Mecklenburg County Bar, and I can usually get you to a law firm that's going to have more of those green flags and that hopefully is going to specialize. And so I will send someone who's a little over income, to Andrew or to Sean, because I know that these are attorneys that are, experienced and good at what they do. So the other way that we offer services is we do free monthly legal clinics. This is a great entry point for anyone that wants to sort of get to know what it's like to work with an attorney. So on the first Wednesday of every month, and they have both volunteered for these clinics, you can apply as long as you're income eligible, which I'll talk about in a minute. We can help you. And you can have an hour with an attorney. Sometimes that's just talking about your business and helping them sort of issue spot and clarify and prioritize. Maybe you're like, I've heard about intellectual property. I don't know if this is something I need to be worried about. I'm still kind of small. Just talk through it with an attorney and they might say, this isn't something you need to be too concerned about now, but 6 months from now, when you hit the next growth point, you're going to want to come back. Or it might be, I've got an hour, I just want someone to look at this contract with me and help me understand it. But those legal clinics can be great, especially for earlier stage businesses when you don't know what you don't know, and you just want some time to think through it. I usually am going to give you either 2 or sometimes 3 attorneys working in pairs. So if you go to our website, which is somewhere here, you can figure out how to apply for services. Generally, what we are looking at when determining whether you're going to be eligible, we're going to look at your total gross revenue in the last year of your business if you are operating. So it's got to be under $1 million in gross revenue. Most of the businesses that we serve are like less than 100,000, but that's our guideline. We look at your household assets. So if you have a substantial investment fund or something that we think you could draw from, we would ask that you hire an attorney. We're really looking for someone that is not able to afford an attorney. And the last thing that we look at is the total income of the household. We base our eligibility requirements on things that come out from the federal government that state basically the federal poverty guideline, and then we multiply it by a number, so it's not worth going through. But it's about, I think, $78,000 for one person. If your whole household income with you, the one person, is less than that, you're probably going to be eligible. But as I mentioned, we talk about a lot of different factors. If you're a little over income eligibility, but you have like a significant financial hardship, we may take that into consideration. And if you're not eligible, we will get you to a person that can help you, hopefully, for something that you can afford. So if you would like to apply for either of those, I would send you to the website. If you just have questions about it, because we didn't get to talk for too long tonight, you can just email me. I'm right there, casey.burke@climenc.org. I'm always happy to answer questions about how we can best help you with your business.
And I'll just add too, I saw some folks like taking pictures of the slides go up tonight. I think we're gonna end up having a copy of the presentation that we can share, because obviously like we kind of like skirted over some topics just for the sake of time. But this recording that we have tonight, we're gonna hopefully post on the Mecklenburg County Bar website, so it should be readily accessible. Worst case scenario, you can contact any one of us and we'll get the materials to you in one way, shape, or form.
And if I may, I couldn't publicly endorse any CPAs, but I can publicly endorse Climb. This is my experience with Climb has been been nothing but fantastic. The work is just an absolute pleasure to perform, and honestly, I come out of it learning something new every time I've done a clinic. So I would not have any hesitation to apply for Climb, because you're going to get top-notch professionals that are going to do a very good job for you.
Thank you, Andrew.
Quick question about the clinics. Are they in person?
They're virtual. They're on Zoom from 12 to 1 the first Wednesday of each month. I should have said that. We made it that way so that if you sign up and then can't come because you're business, the lawyers just at their desk as opposed to this library. Any other questions? Okay.
Thanks for coming.